Hi, good day. Welcome to YES, another talk for YES. Today we're talking about planning strategies for the caregiving child. The YMCA education series is free and open to the public. We encourage you to invite your friends and family to come and hear all the information that we're learning. We host approximately 6 to 8 of these a month. And varying in all types of different topics. Matt is our leader today, and he talks every month, and we are grateful to have him. This program lasts about an hour. If you have any questions, feel free to put it in the chat box, and I can help get that message to our speaker. Most of the times we answer the questions at the end of our talk. And we normally have about 5 minutes for that at the end. And with that, we're going to get started today. Thank you again for joining us this morning. I would now like to introduce to you Matt Margolis. Matt is an elder law attorney with Margolis Weldon. He will be offering planning strategies and important matters to consider for adult children when they realize that they need to help care for their aging parents. Today is planning strategies for the caregiving child. And please welcome Matt.
Hi, thanks, Pam. So good morning, everybody, on this rainy April morning. We can't seem to get rid of this rain. A little bit about me, just so you have a little bit of background. So I am a partner at Margolis Weldon. That sounds weird because there's only two of us, me, Matt Margolis, or yours truly, and my partner, Lauren Weldon. And we've had our practice now for 7 years in downtown Park Ridge. We assist people of all ages, shapes, and sizes, and backgrounds, and whoever you are, we're happy to help when it comes to estate planning and elder law. What does that mean? On the estate planning side, we do a lot of work with, we put together wills and trusts and powers of attorney documents. We work with 18-year-olds, putting together powers of attorneys going for 18-year-olds going up to college. All the way up to working with individuals in their 90s or triple digits who don't necessarily need an elder law attorney, they just need a plan. On the elder law side, we have a really strong focus on helping people apply for Medicaid and a benefit through the VA called aid and attendance, as well as a really strong focus on not just helping people apply for those benefits, but also helping them protect assets in the process of applying. And that's it. Personally, I'm married. I've got 2 little kids. I've got a son in kindergarten, a daughter who will be 3 soon. Our son will be 6 next week, actually. And I'm a Northbrook resident and a former YMCA member for a long time. So, as Pam said, and when you're not sharing your screen, which is totally fine with me, doesn't bother me. Even though I'd love to see all your faces. For asking questions, I would just say for sure, if you can type questions into the chat box, I've got it open on my side, so I'll definitely be looking at it. I promise I'll get to your question. I just might not get to it right away. I might want to finish my train of thought, because if I don't, I will totally forget what I'm talking about. So please feel free to use that chat box for questions that you have. And if you're not sure how to use the chat box, you can definitely show your screen and just kind of like raise your hand, and I might give you one of these again to kind of give me a minute to finish my train of thought, but I'm happy to take questions as long as they're pretty general. Okay, the only thing I'd ask is that they're not super personal questions. I'll put my email in the chat box, and so if you guys have any personal questions, you can shoot me an email, and I'll be really upfront whether it's something I can answer quickly or if it's something that we might have to spend some time on, and there might be a billable fee for, but pretty simple questions I'm happy to answer typically. So all right, I think that's it from like a housekeeping standpoint. All right, so looking at the caregiver child, so number one, if some of you have attended some of my other talks, and I don't know if any of you have or not, but I do have a little bit of sort of overlap in some of the talks I give, and that's just because that certain topics sort of require me, or I feel required to talk about certain aspects that might be applicable to not just this talk, but another talk. So, I apologize in advance if you've attended other talks and some of the information I give today is a little repetitive. I would argue that it probably doesn't hurt to hear some of these things a couple times anyway. because I would say a lot of this is pretty important, at least in my opinion. So when we talk about planning strategies for the caregiver child, in most of these situations, really what we're talking about is sort of like this idea of a situation where we have an adult child who, in most cases, has probably put their life on hold to some extent. I'm not saying that's the case in every situation, but in a lot of cases that we see, we run into these cases where we're meeting with an adult child and their mom or dad or both parents, and inevitably this adult child might have had a career at some point, and then they didn't have to, but they felt like they needed to leave their career to care for their aging parent. And in some cases, we see adult children that maybe never really had a career, and their whole life they've lived with their mom and dad, and sort of like as their parents got older, they just felt the need to stay there with them and to help care for them. I give these adult children a lot of credit, because as much as I talk about it and we discuss it with clients, it's hard. It's really hard to do that. Number one, especially in situations where they've maybe left a career or really put their life on hold, and where they have a family of their own. I mean, it's not easy to do that. I tell clients all the time, at least at this point in my life, I could never imagine doing that, with two young kids at home, especially. And so kudos to those of you that might be in that situation or that have been in that situation. It's really big of you that you were able to do that. And so when we're looking at the idea of planning in this situation, in a lot of cases where there's some sort of focus on Medicaid and protecting assets, and so we're definitely going to spend some time on that. But I really want to start by talking about, because this if you attend my talks, that you're bound to hear me talk about this for 5 to 8 minutes every time, because they're so important. So the first thing I really want to discuss is, and this is not particular to the topic necessarily, but it definitely occurs. It definitely is something that's very important, and that's just really just making sure that if we've got a loved one that's aging, we really want to make sure they've got powers of attorney in place. Again, I bring this up all the time because it is so important. Everybody, I'll make a comment and then I'll sort of justify it. I'm going to say everybody over the age of 18 should have powers of attorney in place. Now, reality, I would at least say that everybody in their adult years, so in their maybe late 20s, early 30s, for sure should have powers of attorney. I'm not going to expect 18-year-olds going up to college to have powers of attorney in place, even though I think that's a great idea, right? Because we were all in college once. We know that we maybe made some less than ideal decisions, and maybe we got lucky that nothing unfortunate happened to us. But God forbid something happened to one of our children or grandchildren at college, and they were over the age of 18, which almost every college student is. We might have issues with dealing with the university or dealing with the hospital or the doctors if there was some sort of medical issue. And so really having powers of attorney in place would be really important. And so when I'm talking about powers of attorney, Illinois has 2 different types of powers of attorney in place. We have a healthcare power of attorney and a property power of attorney. The healthcare power of attorney is a legal document where we're naming somebody to make medical decisions for us in the event that we can no longer make our own. We can name as many people as we want, but it's one at a time in a particular order. Now, I'm not going to go into tons of detail on these documents. I want to give a sort of a brief overview. But so we can name as many people one at a time in order on the healthcare power of attorney. I can't stress that enough. I've had clients come in where they put together powers of attorney on their own. And this just happened yesterday. I had 2 brothers come in with their elderly mother, and they had their mom sign a power of attorney for healthcare 2-3 years ago. And they named the 2 of them, and mom named the 2 of them as her agent under the power of attorney. It said, son number 1 or son number 2. And it can't be written that way. Okay, it has to be written son number 1 first. And if he can't do it, then it's son number 2. And if he can't do it, then we can name as many other people as we want in order, but it's one at a time. We can't name people, this person and that person. We can't say this person or that person. We want to be very clear. It's one at a time. The last thing we want is to execute a power of attorney incorrectly, and therefore it's not effective, and then be in a situation where we need it and a hospital or a doctor or some kind of medical institution is unwilling to accept it. Okay. And so the reason why we have a healthcare power of attorney, again, I probably said this, is that if I'm unable to make my own medical decisions because I'm incapacitated, I'm appointing somebody that can. Okay. If I don't have a healthcare power of attorney in place and I'm incapacitated, it's possible that somebody would need to petition a court to become my guardian, my legal guardian, to make medical decisions for me. There is something called the Healthcare Surrogate Act, which is sort of a backdoor approach, if you will, in avoiding the need to go through a guardianship in court, which can be pretty costly. A guardianship in court can be, in most cases, probably isn't going to be less than $2,000-3,000 in attorney's fees and court costs. And then you're having to check in as the guardian. You're having to check in with the court every so often, which means more attorney's fees down the road. So if I don't have a healthcare power of attorney and I'm incapacitated, we typically look at the idea of a guardianship, but in some cases, we might be able to access what's called the Healthcare Surrogate Act, which is basically a statute in Illinois, which ultimately outlines certain individuals that can step in to make medical decisions for me that are related or close to me. And so I'm not going to go through that list with everybody, but there is sort of a backup in place. However, this backup, the Healthcare Surrogate Act, there is no backup like that when it comes to the property power of attorney. So the property power of attorney in Illinois is a legal document where we're naming somebody to make financial decisions for us in the event that we can no longer make our own. Okay, and it works very much like the medical power of attorney in the sense that I can name as many people as I want, but it's one person at a time in a particular order. Okay. Of course, I want to be making sure that I'm naming the right people, right? Just because my son is older than my daughter doesn't mean that my son should be my property power of attorney, my financial power of attorney. Maybe my daughter's the better person to name because she pays her bills on time. She files her taxes when they need to. Something breaks in her house, she's getting it fixed. My son, maybe he's older, but he's irresponsible. He doesn't pay his bills on time. He's always late filing his taxes. So again, I want you to think about the same thing for the medical power of attorney. This shouldn't be a game of favorites. This shouldn't be a game of us being concerned that we're going to hurt somebody's feelings because we're not naming them first or second or third. I tell my clients all the time, you need to be selfish when you're naming powers of attorney. This is a big deal, right? If you become incapacitated and you need somebody to step in to make certain decisions for you, I want you to be naming the people that are appropriate for that position, whether it's somebody to make healthcare decisions or financial decisions, which is the property power of attorney. So back to the property power of attorney, like I said, similar to healthcare, we can name as many people as we want, one person at a time. And the property power of attorney is going to be the person that can step in to handle everything on your behalf that's not healthcare related. Okay, that's going to be dealing with any real estate you own, your bank accounts, your retirement accounts, life insurance policies, issues that might arise with Social Security or Medicare, filing a Medicaid application on your behalf, signing a contract with a caregiver, moving into a long-term care facility. These are all issues and matters that your property power of attorney would deal with on your behalf. Okay, you're giving this person a lot of power. I tell every client, I want to make sure that everybody you're naming, I don't care if it's the first person or the fifth person, these are all people that you trust and that there would be no issues with them stepping in on your behalf to make decisions. Okay, nothing makes me more concerned that when I have a conversation with clients about the power of attorney taking effect, and I say, if it took effect tomorrow, would you be comfortable with your son having access to your financial records? And the client's like, I don't know, and I'm that's not a response I want, right? That shouldn't be something that anybody's saying when they're naming somebody in this document. Okay. If I do not have a property power of attorney and I am incapacitated, somebody will have to petition the court to be my guardian for financial decisions. Okay. Like I said before, there's no sort of backup like the Healthcare Surrogate Act for the healthcare decisions. There's nothing that exists like that in Illinois. If I'm incapacitated and I don't have a power of attorney for property, somebody will have to petition a court to be my guardian. And believe me, this is not ideal from a cost standpoint. Okay, so from the standpoint of hiring an attorney, going to court, paying for all the costs associated with it, but then also when you're acting as a guardian for somebody for financial decisions, when you're talking about having to wanting to sell their home or apply for Medicaid or moving into a long-term care community or do certain things, in a lot of these cases, you actually need to get court approval to do these things, as wild as that sounds. And so, again, that's not ideal. It doesn't, it's not as flexible. Having to go through a guardianship is not as flexible as having a power of attorney. It can also be pretty restrictive. The court might not allow you to do certain things that you could do if you had a power of attorney in place. So, again, I might have spent more than the 8 minutes I said that I was on this, but I really can't stress the importance of this enough to everybody. It's always unfortunate when we have somebody reach out to us and they have a loved one who's incapacitated. And of course, the first question we ask is, do they have powers of attorney in place? And they say no, because inevitably they will, 95 out of 100 times they'll have to go through the guardianship process. Okay, so powers of attorney aside, when we have adult caregivers in place, child caregivers in place, there are some things that can happen that can be an issue if that older adult ends up needing to move out of the home and move into a long-term care community and apply for Medicaid. All right, these are, it goes without saying that if we're a caregiver child, we're acting in that role, that we're responsible, that we have a sense of responsibility for our parents. And that's why I bring up the idea of making sure that powers of attorney in place. And beyond that, I'm not going to get into this today, but, making sure there's some sort of, will or trust, some sort of document in place that's going to direct what happens with, mom or dad or both parents' estate when they pass away. So of course, we need those things in place, powers of attorney especially. Okay, so all that aside, typically one of the biggest issue we see with child caregivers is this idea of, I can manage my parents' healthcare to a certain extent, but at some point I'm not going to be able to, right? At some point, I might not be able to be that caregiver. And so what do we do? Now, before I get there, let's talk about the situation where somebody is acting as a caregiver. So inevitably what we see is, like I said earlier, we have this adult child, that's put their life on hold, that's left a career, et cetera. They're taking care of mom or dad. And then we see this sort of happening in one of two situations. One, we have the adult child that is still living in their own home and might have their own family, but is spending quite a bit of time caring for mom or dad, okay? And then we have another situation where this adult child, typically in this situation, is not married, might have children, but typically doesn't. But ultimately a situation where an adult child is living with mom or dad, okay? Not so much mom or dad living with them, okay? Very particular in the situation, the adult child living with a parent or parents and caring for them. And so because in these situations, a lot of times what we'll see is down the road, all of a sudden, mom or dad's money starts to run out. And they might need to apply for Medicaid, right? They might need to move into a nursing home or some sort of long-term care facility where they can apply for some sort of benefit to help them pay for their care. Because we know those things may happen, and again, every situation is different, in a lot of cases, what we will recommend is that the adult child and their parent might put together a caregiver contract, okay? Inevitably, in a lot of these situations, we see it where the mom or dad is supporting the adult child. Okay, maybe not directly writing them checks every month, but buying all the groceries for the house, paying the adult child's phone bill, paying the adult child's loan for their car, buying their gas, really paying for a lot of the adult child's expenses. And when if that older adult ever moves into a nursing home or a supportive living facility and applies for Medicaid, okay, those are the two types of long-term care facilities in Illinois that will accept Medicaid. Every single place that's called a supportive living facility, by definition, takes Medicaid. And then there are a number of skilled nursing facilities that take Medicaid. There are plenty of them. And so if that older individual ends up moving into a nursing home or supportive living facility and applies for Medicaid, Medicaid has a 5-year look back period. And what does that mean? That means that Medicaid's going to want to see what did mom or dad, or basically what did the Medicaid applicant do with his or her money over the last 5 years. And Medicaid doesn't care that, my mom, paid the mortgage on her house, paid for any of her utilities. Medicaid doesn't care that my mom just bought a $4,000, flat screen TV. Medicaid doesn't care that my mom took a $15,000 trip to Europe last year. What Medicaid cares about is, did I give any money to anybody else? And really what the term that Medicaid uses is, did I make any transfers for less than fair market value? Okay, so this would be, was I paying my adult child's credit card bills? Was I paying for my adult child's phone bill? Was I paying my adult child's monthly loan on his or her car? These are all, even though I wasn't writing a check directly to my child, these are all things that Medicaid will take issue with, okay? Similarly, just so everybody understands this idea of a transfer for less than fair market value, it's not just gifting money to somebody, it's also in the form of, let's say I had a car and my car had a value of $10,000. And I told my daughter, well, you know what, I'm going to give you a deal because you've been so helpful to me. I'm going to sell it to you for $1,000. Medicaid would look at that as a $9,000 transfer for less than fair market value, or a $9,000 gift, because the value of the car was $10,000 and I sold it for $1,000. So, we really need to be careful as to what we're doing with our money, sort of in the years leading up to a Medicaid application. And believe me, I understand, and I'm very conscious of the fact that there are some situations where people might have a very good idea that Medicaid is on the horizon. And there are also some situations where people don't have any idea. And it's not that they were, giving money away or doing things knowing that they'd be applying for Medicaid. We've had clients over the years where, they had a stroke out of nowhere, totally unexpected, and needed to go into a nursing home, and based on their financial situation, needed to apply for Medicaid. But, they had maybe gifted some money to their children or grandchildren, or whatever it might be. And we get it, right? It wasn't done for purposes of applying for Medicaid, but ultimately now we have to deal with it. Now we have to see what we can do to sort of plan around it, if you will. So I digress a little bit, but so to get back to what I was saying, in some of these situations, if we have a situation where an adult child is sort of being supported by the parent that they are caring for anyway, better than mom or dad paying all their bills, or maybe even just writing them checks, right? In some cases, we do have, clients that have just been writing their adult son or daughter a check for $500 or $1,000 a month, or more than that. So what we do, or what we recommend, is the idea of a caregiver agreement. And, I've had some clients that think it sounds weird to enter into a formal caregiver agreement with their mom or dad. But again, if we're doing this and we want to create and have as few issues as possible, if and when we might be applying, our mom or dad has to apply for Medicaid, then this is the best way to do it. Okay. And so we typically recommend a caregiver contract, and we agree on, some sort of, typically we're not going to do, in some cases, if an adult child is truly, doing things that can be, sort of accounted for on a more hourly basis, then we would figure out some sort of hourly rate. Typically, we're going to figure out a rate that's less than the market rate of what a caregiver company would charge. We figure out some kind of, hourly rate, kind of figure out sort of the average number of hours that person's working a week, and we put together a contract with all this information, along with some of the duties that the adult child is taking on. In most situations, though, especially if it's a situation where an adult child is either, there every day, 12, 15 hours a day, or, in most cases living with mom or dad or both parents, a lot of times what we'll do is we'll figure out, a daily rate that the adult child is charging. And maybe it's a daily rate, it might be a weekly rate, it might be, sometimes we'll figure out a monthly rate. We try to be a little bit more detailed. So typically we'll figure it out based on a daily or weekly rate. But this would pass any kind of issues if and when mom or dad apply for Medicaid. So Medicaid will be fine, even though it's an adult child. Medicaid, it will be fine with, you know, mom or dad paying son or daughter $4,000 a month to care for them, basically 24/7, as long as there's a written contract in place. But if mom or dad was writing that same son or daughter a check for $500 a month with no contract, it would be an issue. Okay. So again, it might sound silly to have this written agreement in place, but I can tell you that it has made the Medicaid application process way smoother in a lot of situations, because unfortunately what happens is, in most cases, by the time somebody comes to see us, you know, people, you all know that as in general, most of us are procrastinators, right? And yours truly, just because this is what I do for a living, doesn't mean that I don't procrastinate in plenty of other areas of my life, okay? And so inevitably what happens is, by the time people see us, it's too late for this, right? You know, they've already been writing checks to the son or daughter, or paying for all their bills. And then, you know, we're basically, you know, being brought into the situation where, at a time when, you know, the parent has to go into the nursing home and they're looking to have us help apply for Medicaid. Then we really have to kind of go through what was done with the adult child and how that child was paid, and try to put something together that we can provide to the state of Illinois to show that, you know, this money really wasn't a gift, that there was a lot of care being provided, et cetera. But, you know, to go back and try to sort of fix the issue, believe me, is not as ideal. And in a lot of cases, you know, whether it's been us or colleagues of ours, we're more prone to be unsuccessful trying to sort of patch up something that's already been done, than in a situation, obviously, where we were able to get in front of it. And I think that kind of goes without saying. I probably shouldn't even need to say that. Most of you would probably anticipate that that's the case. And so, again, I won't go into any more detail on it, but really this caregiver contract is super ideal. And again, I know that we're talking today about the caregiver child, and so obviously this is applicable to a child caregiver, but listen, this applies to any kind of private caregiver. So, you know, this is beyond the child caregiver. If you have a loved one that, you know, has some sort of private caregiver that's not through a company or an agency where you signed a contract in the beginning, and you've got that private caregiver because, you know, maybe they're $10, $15 an hour cheaper, which I totally understand. Fine, but have a contract in place. You need to have a caregiver contract in place with these people. You do not want to be in a situation where all of a sudden you're at the doorsteps of applying for Medicaid, and you're either working with a nursing home, which I would not recommend in that situation if you've been paying a private caregiver, or you're working with an elder law attorney, whether it's us or somebody else out there. The last thing you want to do is all of a sudden be in a situation where you're applying for Medicaid and you've been paying a caregiver privately with no contract for the last 4 or 5 years, 2 years, et cetera. Those are tough situations. Okay, there's a lot of work that has to be done to sort of fix that issue, so that the Medicaid application can be in a position where you're ideally not having many issues with it. Okay, so yeah, I can't recommend the idea of a written contract with any kind of caregiver, whether it's a family caregiver, whether it's a private individual that's not related, but that, you know, you're going down that route because it's less expensive, which I totally get. Again, have a written agreement in place. We can help with that, but honestly, go to another elder law attorney if you really want to, you know, put one together yourself. I don't recommend that, but I'd rather you have something in writing versus nothing at the end of the day. If I'm living with my mom or dad, and ultimately they get to a point where they have to leave the house, because if anybody's been in one of these situations, you know, there typically is some sort of breaking point. Sometimes it is from a physical standpoint, right? You know, the adult son or adult daughter just simply can't care for mom or dad anymore. Their needs have just gotten to a point where they've surpassed what that adult child is capable of helping with. So one is from just a physical standpoint, The other one is, I mean, there's also just the emotional side of it, right? I mean, you know, being a caregiver child, being a caregiver spouse, really takes a toll on people. You know, I always tell spouses, especially, I mean, with children, I say the same thing, right? I mean, to some extent, you know, I tell my clients, I'm like, I want you to be a son or a daughter, and it's like, if you can prevent yourself from being a caregiver son or daughter, that's ideal, because, you know, unfortunately, it's some, you know, what we see is that these adult children come to us, they've been caring for their parents for a while, and they just start to resent their parents, unfortunately. It's not their fault, but, you know, when your life is dedicated to, you know, helping your mom or dad get dressed, go to the bathroom, wash up, um, you know, bathe, take medication, you're taking them to the doctors, you're doing really everything for them. Listen, I mean, you know, it's difficult to do that. You know, I find myself struggling with that at times, just for my two little kids, let alone an older adult who, you know, especially if they're dealing with some sort of cognitive issues, which just can make it a lot tougher. It's tough, right? And it really takes a toll. And so, again, whether it's from a physical standpoint that adult child has just can't really handle it anymore, or from an emotional standpoint, they can't handle it anymore. And I always say that a spouse should not be a caregiver, because unfortunately, we always see that healthier spouse start to decline because they're overexerting themselves taking care of their husband or wife. And so we have like the physical aspect of it being too much, the emotional aspect of it being too much, and then we ultimately, in a lot of cases, what it comes down to is the financial aspect, right? At some point, you know, mom or dad is just not able to stay at home for financial reasons, right? Their funds have really started to decline, and ultimately they really need to be looking at some kind of long-term care facility, and the idea of applying for Medicaid. So I see a question in the chat box: does a caregiver agreement also apply to a spouse taking care of a spouse with dementia? And so I'll answer that question, and really, you know, the dementia piece or not. So would a caregiver agreement apply to a spouse? It wouldn't, only because in a Medicaid, if I'm filing a Medicaid application, if I'm applying for Medicaid for me and I'm married, Medicaid looks at my wife and I as a family unit. And so ultimately, there's really no value in me transferring money from my name to my wife's name. And so that really wouldn't matter or do anything. In this case, this caregiver agreement would really be applicable to everybody other than a spouse. So it's a really good question, just to clarify that point. It's a good question anyway. I shouldn't say that. It's a good question anyway. I'm happy to clarify anything. But no, it is a good question. You know, so the caregiver agreement would really apply to anybody other than a spouse. So it can be adult children, it could be grandchildren, it could be nieces and nephews, and then obviously it could be anybody that's not related to us that we're hiring to help pay for our care, or to help take care of us. And so if we're moving out of the house, right? I'll use the example that I am the senior moving out of the house. It's kind of easy to talk from that perspective. So if I am the senior moving out of my house and looking to apply for Medicaid, either in a skilled nursing facility or supportive living facility, Medicaid I'm going to be allowed to keep $2,000 of total assets in my name. Okay. So I'm going to use the example that I'm a single person, then I'll give you an example of a married couple. So if I'm a single individual, I can have no more than $2,000 in my name, and that's all my assets: checking accounts, savings accounts, retirement accounts, cash value of life insurance policies, annuities, etc. The total of all of that cannot be more than $2,000. Also, I cannot own a house. Now I can own a house, but Medicaid can put a lien on it until it sells. They can put a lien on it for basically to reimburse the state for any money that they've paid out for my benefit. But in general, $2,000 in my name is what I'm allowed to have. No house, no car, no nothing. So if I'm single and I'm moving out of the house and I'm applying for Medicaid in some sort of facility, there are ways that I can transfer assets to that adult child of mine that are not subject to the 5-year look back that Medicaid has. Okay, they're few and far between, but I'll give you the few that we see that come into play. Okay, the biggest one is which I say the biggest one. I think we've maybe seen this happen twice, and I've seen this happen twice in doing this for almost 12 years now. We have what we call the child caregiver exemption for the house. So if I have an adult child that's been living in my home, this cannot just be a child that's been caring for me and living in their own home. An adult child that's been living in my home and providing care for at least 2 years, up until the point of that I move out of the house and apply for Medicaid in a long-term care facility, I can transfer my house to that adult child. Okay, to that child caregiver. This only applies to a child. I don't understand the logic behind it. It does not apply to a grandchild. Okay, so it's only a child. And then there's some other aspects of it. You know, we would need to make sure that we get a letter from a doctor that would support the fact that I actually needed care for the last 2 years, right? And we need to show some documentation that that has been, in fact, the residence of my child for the last 2 years. You know, we can do that typically with tax returns, maybe you know, bills that they receive in the mail, you know, any kind of mail that they receive, et cetera. So so that's one big sort of exception to the 5-year look back, and you know, the ability to transfer the home, which is a big deal, right? Because you know, we don't know for sure the state's logic behind it, but you know, as practitioners, we've all pretty much assumed that the state has kind of offered that this exception or this exemption, because you know, ultimately that adult child, by taking care of me for the last 2 years or 3 years, or maybe it was 5 years, you know, prevented me from having to apply for Medicaid much sooner, right? And so the state is sort of offering this, you know, okay, well, and this has also been your residence. We don't want to kick you out. We appreciate all the work you've done. Here's the house. The other big thing that we see, and not big, but the other situation that we see that can come into play here is that if we have an adult child that is living, that receives SSDI, okay, Social Security disability. So if we have an adult child, and this adult child does not have to have been a caregiver necessarily. So, you know, a little bit on topic, a little bit off topic, but whether this adult child was a caregiver, a child caregiver or not, if we have an adult child that is a recipient of SSDI, Social Security disability, I can transfer as much of my estate as I want to that adult child before I apply for Medicaid. And it's not subject to the 5-year look back. Okay, I can transfer an unlimited amount of assets to that adult child and apply for Medicaid and not have that transfer be an issue. In these situations, and then there's one other, well, not necessarily related to this, so I won't talk about it. This is an example of a single individual. All right, if I have a married couple, and so if my wife and I are married, and one of us needs to apply for Medicaid, but the other one's going to stay at home. Let's say the other one's going to stay at home with the adult child, still caring for them. Ultimately, you know, as far as me moving into the nursing home and applying for Medicaid, all those issues that I just mentioned are still applicable. Meaning, I can have no more than $2,000 in my name. The 5-year look back applies. Okay, so Medicaid's still going to look at what I did with my assets over the last 5 years, and they will actually look at what both my wife and I did with our assets. Okay, as a married couple, they're going to be concerned about both of us, not just me. And the one thing I didn't mention before is that if I apply for Medicaid as a single person, I get to keep, in a nursing home, I get to keep $30 a month of my income. All right, so if I get $2,000 from Social Security every month, I get to keep $30 of it. The rest of it goes to the nursing home, and then Medicaid picks up the remainder of the tab, if you will. If I'm in a supportive living facility, I get to keep $90 a month of my income, and then Medicaid picks up the rest. Okay, that's really one of the biggest differences between how Medicaid works for supportive living facilities and skilled nursing facilities. However, if I'm married, my spouse can have up to $109,560 in her name, plus a house, plus a car. Okay, so I can have up to $2,000 in my name. My spouse can have $109,560, a house and a car. And there's no, at least at this point in time, there's no maximum value as to what the house can be worth. You know, in most cases where we're looking at Medicaid, I'd say most of our clients probably don't have a house that's worth more than $500,000-$600,000. But you know, you could have a house worth $1 million. and still apply for Medicaid in the situation, and the spouse will be entitled to keep it. It's 10 o'clock. I've got until 10:15. I don't really have much else to cover, but I'd be happy to take some questions if anybody has any questions or comments. And even if it's, a little bit, even if it's somewhat related to what we're talking about, I'm happy to answer any questions anybody might have.
Any questions from the group? So, well, I can tell you Matt's next talk will be on May 4th, the ins and outs of Medicaid and what to watch out for. So we can get excited about that. Oh, there's I
see a question. So, all right. So there's one really long question that was directed right to me, and I sent a message to you. Please send me, so to that person, please email me that question, because that's a lot longer. I won't be able to cover that right now, and it's very personal. So Katie, what if a parent has paranoid disorder and does not trust anyone to set up a POA? Yeah, so this is something that we've seen before. This is a hard question to answer. I'll kind of give you my 2 cents on it, and you might have other practitioners that that I would imagine other people would say something very similar. Unfortunately, so I don't try to do or sort of sell my services through fear at all. There are some professionals that do that, right? That's just not how we operate whatsoever. However, with this particular question, I typically tell my children of potential clients that this might be something where you do need to instill a little bit of fear into your parent, because I totally understand the paranoia of signing a POA. There are people that just have this idea of they don't want to give up control, right? They're concerned that if they sign this POA, somebody's gonna step in and take control over all their stuff. Well, so there's 2 ways that a power of attorney can take effect, whether it's healthcare or financial. And they can take effect either immediately when we sign the document, which I'll tell you, a lot of my clients, vast majority of my clients are comfortable signing it so that it's effective immediately. Especially my clients that are a little bit older, right? There's just a matter of convenience that, my adult son or daughter, my spouse can sign my name, pay my bills, etc. But I'm not giving up my right. Even in that example, I'm not giving up my right to do it, okay? My power of attorney for property was effective the day I signed it 8 years ago. Has my wife ever acted on it? No. However, it can be signed in a way where it doesn't take effect until that person becomes incapacitated. And so one thing I would really look to, try to discuss with your parent or loved one that might feel this way is, first and foremost, making them understand that this document does not have to take effect until they're unable to make their own decisions. And so they're fully capable of making their own decisions until then. And it would never take effect until a doctor were to put something in writing saying that they can't manage their own affairs. However, I think one big selling point here is that if they're incapacitated and they don't have a power of attorney in place, anybody can petition a court to be their guardian. Versus if they put a power of attorney in place, they are getting to decide who that person is. They are picking the person that's going to step in and make decisions for them when they get to a point where they can't. So by putting the power of attorney in place, it's actually the exact opposite of losing control. They're able to have total control over the person that will make decisions for them. Whereas again, if they do not put a power of attorney in place and they're incapacitated, maybe I would have wanted my daughter to be my power of attorney, but ultimately when the time comes and I'm incapacitated and I don't have a power of attorney, my son is the one that petitions the court, and my daughter doesn't really want to fight it, and she just lets it happen. And now I've got my son doing it, and maybe he'll do a fine job, but ultimately he's not the one that I would have wanted. And so I think it's 2 things. It's making sure that you're picking the person versus a court picking the person. And number 2, without the power of attorney, the guardianship, if you have to go through the guardianship route, which 95 out of 100 times, if you don't have a power of attorney and you're incapacitated, you will have to go get a guardianship. You're looking at a more expensive process. You're looking at hiring a lawyer. You're looking at attorney's fees, not just to get the guardianship up and running, but then on an annual basis, you're looking at attorney's fees to check in with the court. And then when certain things want to be done, you need to get court approval. So this is one of those things where I put a little bit of the fear, a little bit of fear into them. If you have to, because, it really is important to have these documents in place. I totally get the paranoia. It's just how some people, I don't really get it because it's not how I am, but I do understand it. And I've seen it over the years. It's not, so you bringing this up, Katie, isn't the first time I'm having somebody mention it. It's the best answer I can offer, but I think some of those are good talking points. And of course, if you ever forget, you're welcome to shoot me an email. I can follow up with you. There's another question, what was the amount of money a spouse can have while applying for Medicaid? So yeah, so just to be clear, so if I'm applying for Medicaid, if I'm the one applying for Medicaid in the nursing home, I get to keep $2,000 in my name. My spouse can have $109,560. It's a pretty specific amount. $109,560, a house and a car. However, the one thing I do want to add on top of that is that in some cases we'll have a situation where, let's just say the husband, I always pick on the guy, the husband's moving into a nursing home applying for Medicaid, and the husband and wife have a 4 or 5 bedroom house, right? It's the house they lived in for 50 years, they raised a family in, etc. And they know that even as of late, it's been too big of a house for them. But now especially the fact that the husband is moving to the nursing home, the wife really wants to sell the house and downsize, right? She doesn't want the 5-bedroom house. She wants a 2-bedroom condo somewhere. And so what we'll typically advise those clients in that situation is, wait until the Medicaid application gets approved. Once the Medicaid application gets approved, you can go ahead and sell that house for $600,000 and go buy a $250,000 or $300,000 condo. And now you can have more than $109,000 in your name. So once a Medicaid application has been approved, not applied. Once a Medicaid application for my spouse in the nursing home has been approved, if all of a sudden my assets increase over that $109,560, whether it's because I sold a house and then downsized and bought a condo and now I've got more cash, or I inherited money from somebody who passed away, it's not an issue if my assets become more, go above that number. But again, only after my spouse has been approved for Medicaid. Cannot happen until then.
You saw the other question about amount of money a spouse can have while applying for Medicaid.
Yeah, yep.
Okay. All right.
That's it. That's all I got. Unless there's any other questions.
This concludes our talk, if that's okay. Thank you, Matt. That was awesome. And again, Matt will be talking next month about Medicaid. If you have any questions about that, I'm glad he will speak to that and then also be able to answer any other questions you have. Programs like this are free and available online. You can check us out on our website for any of our other programmings. May just got put online. We hope to see you at our next event, which is Friday, April 8th. Why going green is the future. So Anna Harris will be talking to us about nutrition and your health. So have a wonderful day, everyone. Thank you again, Matt, and we'll see you soon. Bye, y'all.
You're welcome. Have a nice day, everybody.